Can you settle your case while the jury is out deliberating? Would you like to know the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. The answer is yes, you can settle your case while the jury is out deliberating. Now, it's a risky move. Why? Because at this point, you have now gone all the way to trial. Closing arguments have taken place, the judge has given the jury the instructions on the law, and now the jury is going back to deliberate to try and reach a conclusion about whether or not you are entitled to compensation or not. Now, during the course of jury deliberations, I have to tell you that's one of the most stressful times of trial. Why? Because neither side has any idea what's going on. Nobody knows what's going on behind closed doors when the jury's deliberating. So everybody paces the halls, everybody walks around, and nobody truly knows what's going on. The only time we have an answer is when the jury sends a note to the court clerk letting them know that they've reached a decision. So, can you settle your case at any point, including the point that they're deliberating? The answer is yes. Now, in some cases, the parties, the litigants, may decide to do something what's known as a high-low agreement. Why would they do that? First of all, high-low agreement sets parameters of what the likely outcome could be. Here's an example. Let's say the jury's now deliberating and you have a significant injury and you believe your injury is worth $5 million. Well, in order to try and create a settlement, the defense may say, listen, let's do a high-low agreement where the maximum we will pay is $1 million. If the jury comes back and says, we will not give you anything, then your agreement will provide that you will still get something, let's say $100,000. So that's known as a high-low agreement. And if the verdict falls anywhere in between then, the parties agree to accept whatever the jury has awarded. But let's say the jury awards $10 million. Well, according to that agreement, the maximum you can get would be the $1 million. And if the jury awarded, let's say, $10,000, the minimum you could get would be what you agreed on, which would be, say, $100,000. And the reason that's done is basically to hedge your bet. You're taking a risk, and so is the defense. They're hedging their bet against getting hit for a large verdict above what they're willing to pay. And on the other hand, you're hedging your bet that if the jury comes back against you, you're still going to get something. So why do I share this really cool information with you? You know, I share it with you just to give you an insight and an understanding into what goes on into the litigation process here in the state of New York. And I recognize that you probably have your own questions, your own legal questions about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I'd like you to do and what I encourage you to do is pick up the phone and call me. I can answer your legal questions. I handle these questions just like yours every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks so much for watching.